So, our speaker today is Michelle Paradis. Michelle Paradis currently serves as a senior attorney for the Department of Defense, Office of the Chief Defense Counsel. In that role, he is regularly appointed to represent detainees held at the U.S. Naval Station in Guantanamo Bay, Cuba. He has argued numerous cases before the nation's highest courts and has contributed to scholarly publications on the subjects of the international humanitarian law and terrorism. He received his BA and JD degrees from Fordham University, as well as a doctorate degree from Oxford University. Mr. Paradis.
Yeah, thank you. So thank you for all coming out today. I have a PowerPoint, but I'm not going to hopefully bog down with PowerPoint slides. The issue I want to talk today about is discrimination, and discrimination particularly against non-citizens, and how that plays out in the terrorism context. How does one change slides? Just click it. All right, and so I figured I would start with this poem, and I think you all have seen this poem. I hope you've all seen this poem by Martin Niemöller, who was a Lutheran pastor during in the period of Nazi Germany. And he begins by saying, first they came for the socialists, and I'm not a socialist, and so I didn't say anything. And then he proceeds to the trade unionists, and then the Jews, and then to him. And he says, ultimately, they get you too. And when they come for you, there's no one there to stand up for you. And I really like this poem, and I think it speaks a lot to the issues we're dealing with today. First, because it's about complicity. And it's about our complicity in allowing illiberalism to take hold. So, part of what he's saying is that there's an incentive to keep quiet, to stay safe, to stay on the inside, to be a member of what the Germans would call the Volk, right, the true people. And I think another piece of what he's saying is that that's also a foolish belief, if we can do that, because illiberalism, by its nature, and the Volk by its nature, is very exclusionary. It defines itself, its value comes from what it is not. And if we think back in our own history, right, during Jim Crow, when you had colored water fountains, why did we have colored water fountains? Well, it's because the only way to have a white water fountain is to have a colored water fountain. It gives you, regardless of what your socioeconomic status is in the Jim Crow South, it gives you the opportunity to say, I'm worth something. I'm part of something. And what he reminds us is, what he reminds us of is that that's a dangerous place to put your value. Because inevitably, when you're talking about the Volk, and you're talking about exclusion, it depends for its value on always keeping more and more people out. And so over time, he's saying, look, you can't be assured of your own safety because you very well may be the chaff the next time the wheat gets refined. I think another point he's making, and I think it's the most important point for the times we live in today, is that illiberalism is subtle. It very rarely happens suddenly. It happens at incremental steps that at each point are consensus in some way, or at least accept a liberal consensus. And so I look at his hierarchy there, right? First they came for the socialists. Socialists in the 1920s and 30s were widely viewed as terrorists and sympathizers with Soviet communism. And so it was common throughout the West, not just Germany, to be terrified of socialists. And then you go to trade unionists who are sort of a light form of socialist. And then to Jews, and in the 20th century, the early 20th century, the Jew, what race, what nationality was more associated with communism than the Jews, who could claim Marx, Trotsky? And I found this quote from a so-called liberal thinker, an essay in 1920 called Zionism versus Bolshevism, where they lament where the author laments the violence of, quote, terrorist Jews, and the conflict, quote, the conflict of good and evil which proceeds unceasingly in the breast of man nowhere reaches such an intensity as in the Jewish race. The dual nature of mankind is nowhere more strongly or more terribly exemplified. And so because of this, Winston Churchill, who's the author of this piece, puts a familiar burden on, quote, good Jews that we often, I think, now see with respect to, quote, good Muslims. And he says it's up to the good Jews to come forward on every occasion as many of them in England have already done, and take a prominent part in every measure for combating the Bolshevik conspiracy. And so what this poem tells us is that illiberalism accretes. It comes slowly. And at each point there's a decision point at which liberals are willing to civilly agree to disagree. And by the time it's too late, too many people have agreed to disagree. The one major point at which I would depart from Niemöller's poem, and the theory of it, I think it describes the mechanics of illiberalism very well. But what I want to talk today about is the first step, because he talks about the socialists being the first step. And in illiberal countries, very rarely is it the ideological opposition that they come for first. Instead, they come for ideological opponents typically on a path that has been paved by oppressions meted out on non-citizens. And why is that? Well, for one thing, citizenship is very clear. It is the clearest way that the law can create an us and a them. And it's exclusively defined by law. So who is not a citizen is ultimately a political question, and we give a lot of deference as a result to that. And it's because of that deference that citizenship tends to be the most vulnerable entry point for illiberalism to grow. And so what I wanted to talk today is about one of those specific entry points, and that is the denial to citizens of equal justice under law. Now, I focus on this because it has a lot of relevance to the work I do and the work that Captain Major Swick, who's sitting in the front, does on the military commissions in Guantanamo. Some of you may know this, but the military commissions are governed by a statute Congress passed called the Military Commissions Act. And for a liberal lawyer, there's plenty to dislike about the military commissions and the Military Commissions Act. They have no independent judiciary. They allow for hearsay evidence. They allow for evidence derived from torture. The statute, in many respects, creates ex post facto crimes. And and in fact, the judges are subject to essentially the political and direct influence of the prosecutors. But what makes all of that possible is another feature of the Military Commissions Act, which is that it segregates the court system. Only non-citizens can be brought before a military commission in Guantanamo. And I don't think any of these deviations would have been possible if it weren't for that segregation. But when you think about that segregation, ultimately it means that there are 23 million people in this country who are subjected to this law. And they're subjected to this law without any political voice in whether or not it's being applied. And in fact, if we look at the legislative history of the Military Commissions Act, we see that's exactly what Congress was up to. They were concerned that if citizens were subjected to the rump procedures of the military commissions, that they would be politically accountable for that. That it would be something that they would have to answer at the ballot box. It was not, as some have suggested at least, had nothing to do with the relative danger of citizens versus aliens. And if you think about it, of course it couldn't. Right? Think about the major terrorist attacks. Assume we just limit the terrorist attacks to Muslim terrorist attacks over the past 10 years. San Bernardino, the Pulse nightclub, Fort Hood, the Boston bombing. All of these were citizens. These are citizen terrorists. So of course citizens are at least as dangerous, and in many respects far more dangerous than non-citizens when it comes to terrorism. And I'll read one quote from the congressional record, because I think it actually illustrates how absurd Congress knew how absurd the distinction it was making actually was. And so it's Representative Byers saying, "Let's say an American citizen has been arrested for aiding and abetting a terrorist, maybe even participating in a conspiracy, or maybe participating in an action that harmed or killed American citizens. That American citizen cannot be tried in the military commissions. His co-conspirators could be. They could be tried in a military commission if they were aliens. But if the other co-conspirator was an American citizen, they will be prosecuted in a federal court." And so you have this deliberate intent to discriminate, and done for the most invidious purpose, to cause a breakdown of the ordinary democratic forces that ensure rational and fair lawmaking. And I would look back and think, right, that in the Declaration of Independence, the first self-evident truth is that all men are created equal and endowed by their Creator with certain unalienable rights to life, liberty, and the pursuit of happiness. And the Constitution codifies that in both due process clauses, right, that no person shall be denied life, liberty, or property without the due process of law. And I want you to focus on the language of the due process clause. It doesn't say no citizen. It doesn't say no member of our community. It doesn't say no member of the Volk. Right? It says no person. Because certain inalienable rights, such as equal justice under law, adhere into personhood, not into citizenship. They are not a privilege of membership. And so, unsurprisingly, the only instance in which the Supreme Court ever reviewed the segregation of the justice system on the basis of alienage, it struck it down as unconstitutional. And I'll mention this case a little bit. So the case is called Wong Wing versus the United States. And it arises in the context of what was called the Yellow Peril. And if you think American politics respecting Latino immigration is ugly and fraught and disturbing, you should go look at the Yellow Peril and the treatment of Chinese, typically laborers on the West Coast, and how they were dealt with inside the United States. And so one of the things Congress attempted to do in order to deter Chinese immigration, illegal immigration, into the United States, was to not only make undocumented Chinese laborers deportable, it created special commissions, special courts that were authorized to punish, to sentence Chinese laborers illegally in the country to hard labor, to essentially serve prison terms at hard labor. And the Supreme Court struck that down. And notably, they did so in 1896. And why is that year important? Well, in 1896, the court also decided a case called Plessy versus Ferguson, which you may be familiar, and established the doctrine of separate but equal. So this is not a Supreme Court that is particularly concerned with the rights of minorities. Yet, the segregation of the justice system was the bridge too far. And it was the bridge too far because under that due process, quote, is guaranteed without regard to any differences of race, of color, of nationality, and the equal protection of the laws is a pledge of equal laws. Even aliens shall not be held to answer for a capital or otherwise infamous crime unless on presentment by indictment of a grand jury, nor be deprived of life, liberty, or property without due process of law. And so, in full disclosure, I have a case right now that's being petitioned to the Supreme Court on this very issue, on the segregation of the military commissions on the basis of nationality. Whether or not the Supreme Court will grant, I don't know. I won't bog you down with all the legal arguments, but I wanted to point out simply in the last few minutes of this talk the dangers inherent. So even if it's not strictly speaking illegal and unconstitutional, there are real dangers to segregating the justice system. And to illustrate those dangers, I think it's important to look at how unprecedented the segregation of the military commissions are. Because if you look at history, military commissions are not shining moments in American legal history. They were criticized in whether it's the Lincoln case or the trial of the Japanese after World War II. They were criticized for their lax procedural due process at the time and continue to be so. But even then, the United States never segregated the military tribunals. Citizen war criminals were always tried alongside non-citizens because it was the character of their conduct, not the cover of their passport, that determined whether or not they were a war criminal, whether or not they were a danger to national security. And as a contradistinction to that, we look at the other who did segregate their military commissions in World War II. Well, I think you can guess. It was Japan and Germany. Japan in 1939 passes its own military commissions law, subjecting only non-Japanese citizens to summary trial before a military tribunal. Germany in 1941 passes the Night and Fog Decree, again limiting its jurisdiction to non-Germans who are acting against the state. And after the war, we prosecuted German and Japanese lawyers and judges for participating in what we called at the time terrorism, the use of the legal system to terrorize. And part of that was just the basic denial of equal justice under law. But another part of it was that when you segregate the justice system in this way, invariably procedural shortcuts are going to be taken. Because if rights are just now privileges of citizenship, any procedural protections are noblesse oblige, right? The idea that we're just giving it to you gratis because we're nice people. And when defendants in these tribunals objected to various aspects of the procedure, they were met with disdain for their ingratitude about all the other procedural protections they were being given. And so I think the precedents that we look to are when we are segregating the justice system for the first time in U.S. history, when the precedents reflect essentially people we treated as war criminals. I think that suggests the danger that we are venturing into. But I'll point to one other example because I think it's ultimately informative. Because there was one other example of the segregation of the justice system, and the Supreme Court never reviewed it. So far as I can find, it was actually never reviewed in any federal case. But it came out of the context of the problem of slavery. And how do you prosecute slaves? So why is that a problem? Well, for one thing, slaves are already under bondage. And so to the slaveholding mind of the 18th and 19th century, it made no sense to put a slave into prison because they're already essentially prisoners. And if anything, you are hurting the real party in interest, who is the master of the slave, whose property is being taken away from them. And so how was this dealt with? It was dealt with by what I'll generally call slave commissions. These were essentially a resurrection of an archaic kind of tribunal in England called commissions of oyer and terminer, which have a dubious history all by themselves, but basically involved a magistrate, essentially a policeman, a non-judge judge, presiding over a trial, perhaps joined by other slaveholding males as a kind of tribunal, to determine whether or not corporal punishment should be meted out to slaves who committed crimes against third parties, like hog stealing, which was a capital offense. And so this system of slave commissions was in use almost up until the beginning of the Civil War. And it presents certain dangers, right? In the people at the time were concerned, white people at the time, I should say, were concerned, that the more procedural protections these slave tribunals engaged in, it created a bad precedent for the trial of whites. Because you're saying, well, there's a certain amount of due process that's basically due. And if that floor can be met with someone like a slave, that certainly, there are at least reasons to say it could be met for a white person. And why is that? Well, because citizenship has nothing to do with any innate characteristic. Like wealth, the only people who seem to value it a lot are people who are born into it. But with respect to most other aspects of humanity, being a citizen, being not a citizen, is not very relevant. And so what happens is citizenship becomes essentially a lubricant for accepting weak arguments. Citizenship becomes it becomes a thumb on the scale in the presentation of other arguments for the denial of due process that might not otherwise succeed. And then it's not difficult once that precedent is set to take the thumb off the scale and say it applies to citizens as well. And so the danger of the slave courts, one of the dangers of the slave courts, was that it was setting a precedent for the potential trial of whites, and this was terrifying. Now, I don't want to give you the misimpression. These were horribly procedurally irregular tribunals. But it certainly pointed to a genuine danger that we have seen in the war on terrorism. And I'll point to two cases. One is the case of El Shifa Pharmaceuticals, where the D.C. Circuit Court of Appeals said that Sudanese citizens could not sue the government for essentially military strikes against their property. The case arose out of the embassy bombings and President Clinton's decision to initiate an airstrike against a chemical factory in Khartoum. And the D.C. Circuit said, no, non-citizens have no due process right against targeting, like military targeting. And then 10 years later about, the United States used drones to kill Anwar al-Awlaki, an American citizen, a Muslim American citizen. And what precedent was used? What precedent did the court rely on in dismissing his case to say that even a Muslim American citizen could not bring a lawsuit for being targeted by a missile? Al-Shifa Pharmaceuticals, right? Because ultimately the citizenship question, even though it helped the court swallow the decision in Al-Shifa, wasn't ultimately necessary because it's a question of military power. I'll give you another set of examples, is that there are a number of cases from around the country, but especially in the D.C. Circuit, dealing with the detention and torture of non-citizens. And the D.C. Circuit consistently holding that Muslim Americans are not entitled to sue for damages arising from torture. And just last year, in a case called Mishal versus Higginbotham, the D.C. Circuit looked to those cases and extended the rationale to citizens, to a Muslim American citizen who was essentially held incommunicado and ultimately subject to abusive treatment in Kenya. And why is that? Well, it's because citizenship isn't all that relevant. And particularly in the first step, citizenship essentially helps the bad legal argument go down. And in the second step, the Muslim Americans, and I use that phrase pointedly, because the Muslim American citizens are only deemed to be technically citizens, right? They're technically citizens, but the rationale of these cases applies. And so it's a very dangerous slippery slope because it's ultimately the golden rule, because how you treat non-citizens is ultimately reverts back and becomes the rule by which you are governed. The second piece that's dangerous, though, and I think the slave courts exemplified, is their very inferiority. They were intended to be inferior. They were intended to be separate and unequal. And in the case of Dred Scott versus Sanford, they come to play a very dubious role. Because one of the things that happens once you start, as I said in the beginning, one of the things that happens when you start making citizenship the be-all and end-all of substantive rights, who and who is not a citizen starts becoming more malleable. You have President Trump right now saying that terrorists should be stripped of their citizenship. Green card holders are being treated as any old other immigrant. So people even with substantial connections to the United States are increasingly being denied the privileges of citizenship. They are not part of the Volk. And we saw this in Dred Scott versus Sanford, where Chief Justice Taney analyzes the question of whether or not free blacks, not slaves, free blacks are entitled to citizenship under the United States Constitution. And in a long and very tedious opinion, he looks to all of the various rights deprivations to which blacks and slaves had been subjected to throughout the antebellum period. And he looks to I'll pull up the quote, and he looks to, for example, some of the apartheid laws in slaveholding states, and refers to the special laws and police regulations which the slave states considered to be necessary for their own safety. And here he's referring to the slave commissions. And why that matters is that it was a very short legal step to go from the rights and the segregation of the justice system and what that implied for the rights of slaves as non-citizens to deprive free blacks who were born here of their citizenship. And I would equally say that it is a very short step to say that the military commission's segregation on the basis of nationality and the segregation of justice system there is the kind of, it invites the kind of illiberalism that we are increasingly and justifiably beginning to fear. Because it is the kind of liberalism that forces us to think at each step, with each executive order, with each tweet, are we still going to be inside? Are we still going to be part of the Volk? And it's the problem ultimately that Niemöller was talking about, is when citizenship becomes the source of rights as opposed to humanity or personhood, all of a sudden citizenship becomes a lot more valuable and much more precarious for all of us. It's a rule that starts applying to minorities and soon applies as oppression to us all. And so I would simply say, as a sort of remark of conclusion, that encouraging you, particularly as law students, and particularly as law students at one of the great American law schools, is to really ask yourself in a hard and fast way, what is my line? What is my line on this continuum? Because, you know, you as a lawyer have a unique power to speak up. And you should use that power to speak up, not just for yourself. So that's all I have to say. Any questions? I've silenced you. Well, I think it's time, so thank you very much.
Thank you very much,
Yeah, I
Professor.
appreciate it.
Thank you very much, Professor Paradis. Thank you all. Really appreciate it.
Yeah.
For those of you who are, we're planning on staying for Professor David Lubon's lecture on backsliding in international criminal law. He is unfortunately feeling under the weather today, and so will not be giving that presentation. Instead, the next presentation will be at 1 o'clock, Professor Rosa Brooks on the role U.S. allies play in keeping the U.S. honest. We very much look forward to seeing you all then. Thank you.
Good afternoon, everyone. Thank you all for coming. My name is Noor Al-Kebi, and I'm Georgetown Journal of International Law Symposium Editor for 2017. Just like to give a brief introduction to our next speaker. Professor Rosa Brooks is the Associate Dean for Graduate Programs and Professor of Law at Georgetown University. She also writes a column for foreign policy and serves as Senior Fellow at New America. From 2009 to 2011, Professor Brooks served as counselor to Undersecretary of Defense for Policy Michelle Flournoy. From 2005 to 2009, Professor Brooks was a weekly op-ed columnist for the Los Angeles Times, and her experience also includes stints as senior advisor at the U.S. Department of State and special counsel to the president of the Open Society Foundations and as a consultant for Human Rights Watch. Professor Brooks has taught at Yale Law School, Harvard, and the University of Virginia, and has served as fellow at the Carr Center at Harvard's Kennedy School of Government. She currently serves on the Open Society Foundation U.S. Programs Advisory Board and the Harper's Magazine Foundation Board. Her most recent book, How Everything Became War and Military Became Everything, was published in August 2016 by Simon & Schuster. Please help me welcome Professor Brooks to the stage.
Hi, guys. I feel like we should all come over here. I'm told that there are hordes of people watching this on their tiny little computer screens in other places, so I have to stay up here. But thank you all for coming. I know there are a lot of events going on today. So I'm not an expert on recent events in international justice. At one point, this was an area I followed very closely, partly because it's gotten so discouraging. I have followed it less closely in the last few years, but I thought I would focus on a sort of different issue. I know you've probably heard a lot today already about the sort of nitty-gritty changes and challenges in the international justice domain. I thought I'd make sort of 3 points today, and one, just briefly going over what's probably familiar ground, talking a little bit about the ways in which we've seen substantial progress in the field of international justice, but it's very, very fragile. 2, the ways in which the advent of the current presidential administration of the United States, the Trump administration, I think poses some very serious threats to the fragile progress that's been made. And 3, in some ways the most important point, talk a little bit about the role that U.S. partners, U.S. allies, and even sometimes U.S. adversaries have in trying to keep the U.S. on the straight and narrow and trying to keep the U.S. from playing a role of the, you know, the skunk in the garden, or I can't remember what the metaphor is when it comes to international justice. So first, let me just say a few words about the semi-good news, right? We really have seen amazing progress in international justice in the 20 years since I graduated from law school, when the ICC was still just not, you know, the Rome Treaty had not yet been signed. There really were only a few fledgling international justice institutions, the International Ad Hoc Criminal Tribunal for Bosnia and former Yugoslavia, for instance, et cetera. Today, the situation looks different, and it looks a lot better. The International Criminal Court, we have 120 countries around the world accept the jurisdiction of the International Criminal Court. That's the large majority of countries around the world. The ICC has managed to investigate about 300 cases in its short history, and has 150 convictions to its credit of people who have committed grave crimes in countries all over the world. We've also seen successful regional international justice efforts from Cambodia, Guatemala, to Sierra Leone and elsewhere. And we've also seen, I think, overall, although the trend has had some backsliding at times, a trend towards renewed interest by national governments in enforcing international justice in their national courts. For instance, Germany's current efforts to prosecute people for involvement in the Syrian genocide. So that's the good news, but as you know, it's very much been a one step forward, 3/4 of a step back kind of process as we look at the movement over the last 2 decades. It's been slow, it's been episodic, and we have seen some real threats to that forward trend. One of them, obviously, has been the unhappiness with the International Criminal Court in Africa. And the call by the African Union for African countries to all withdraw from the jurisdiction of the International Criminal Court, coming out of a lot of skepticism about the fact that so many of the court's investigations focused on African cases. And obviously, you can defend that, and you can say, hey, look, every continent on Earth has taken its turn in terms of atrocities. If you want to look at Europe in the 1990s, it was the conflict in the former Yugoslavia. Latin America has certainly seen its day, I wouldn't say in the sun, but significant atrocities during the 1980s, 1970s, 1980s. Asia, in terms of places like Cambodia, we've seen terrible atrocities in the past. So, you could certainly make the argument that it's Africa's only being singled out because it has happened for a variety of complicated reasons, that in the relatively recent past we've seen some horrific conflicts in Africa. But on the other hand, I think the ICC, as you know, it's the one major critique that can be leveled at it is that it is slow and it is distant from the affected communities. And it's not always attuned to the political realities on the ground. So the fact that we've both seen a call from the African Union for withdrawal, and we've actually seen a number of countries, including South Africa, and also I think Burundi and Gambia actually withdraw from ICC jurisdiction is obviously pretty worrying in terms of the future of international justice and the credibility of the International Criminal Court. We've seen a lot of reluctance from several African states to cooperate with the court's indictment of al-Bashir in Sudan. We've seen the collapse of the prosecutor's case in Kenya against Uhuru Kenyatta. And we have more broadly in other parts of the world, we've seen some things that make it a little hard to feel super good about progress. Obviously, the ongoing atrocities in Syria, without any apparent, so far, coalesced international will to do much of anything, either to end the conflict or to bring to justice those who have committed the worst atrocities, is kind of an open sore. And we've also seen a trend of superpowers continuing to do some things that really fly in the face of broader commitments to international law and principles of legality and international justice. And a couple of examples. One, of course, would be Russia's recent actions in the Russian annexation of Crimea. Another would be China's actions in the South China Sea and generally thumbing their noses at the tribunal judgment that China was in the wrong. And, of course, right here in the United States, and this brings me to point 2, we have a new president who has made it very clear that he has absolutely zero respect for or interest in international justice institutions or international norms more generally. And that's a real shift. So let me get to that point of the new Trump administration. We've actually had about a decade of cautious U.S. embrace of international justice institutions Although the George W. Bush administration initially repudiated the International Criminal Court, and we had the infamous John Bolton, then U.S. ambassador to the UN, unsigning the ICC. In the second part, and I forgot to mention the other problems, Russia, of course, has announced that it's withdrawing its signature from the ICC as well, following in the footsteps of John Bolton. By the end of the Bush administration, the second term of the George W. Bush administration, we saw really what amounted to a substantial shift in attitudes towards the ICC and a lot of cautious cooperation with the ICC. And when President Obama came in, that accelerated, and the Obama administration, although it didn't go so far as to actually ratify, began to participate in ICC events very actively and play an increasingly active role, also in providing intelligence support and other forms of assistance to the International Criminal Court. I don't think that's likely to continue. President Trump has not yet. I think the ICC is still too small for him to have quite noticed it specifically, but the people in his inner circle, including John Bolton, who is still here, luckily not the ambassador to the UN anymore, but nevertheless still around. Clearly, people in his inner circle do not like the International Criminal Court. They do not like the United Nations. They do not like international law one little tiny bit. And I think we can certainly expect that we will see a substantial waning, at best case, substantial diminishment of active U.S. support for international justice institutions, and quite possibly we will see a return to the period early in the first Bush administration of active hostility from the United States government towards international justice institutions. President Trump himself, even more worrying sometimes, that's just an issue of how much the United States supports or opposes international justice institutions. But I think even more chilling for many of us, President Trump, while on the campaign trail, indicated his enthusiasm for certain actions that would constitute international crimes if he actually carried them out, ranging from his comments on torture. I believe he said on the campaign trail a number of things such as waterboarding works, and even if it doesn't work, they deserve it anyway. And I'm going to waterboard people and a hell of a lot worse, and so on and so forth. And although he seems to have sort of walked back from his assertions that he was planning to imminently torture anybody he could find to torture, I'm not quite sure who he was going to torture, but I guess he figured the U.S. would grab somebody who could be tortured. Thanks to General, now Secretary of Defense, James Mattis's opposition, President Trump seems, for the moment at least, to have sort of walked back his commitment to restore the use of waterboarding and a hell of a lot worse. But who knows how long that will last. Trump has made it very clear that this is not because he himself is persuaded, that he's just sort of doing Mattis a favor by deferring to him for the time being. Also on the campaign trail, President Trump, then candidate Trump, commented with regard to ISIS, that the Obama administration had been ineffective in combating ISIS, and this was because they were not aggressive enough, and that the only way to get the terrorists is to go after their families, as he put it, and start bombing the children of terrorists, and that would be the only way to have any impact on the leaders of ISIS. When it was pointed out to him that this would amount to a war crime under international law, he was quite dismissive of that. And when the issue of whether U.S. military commanders would obey an order to target the family members of terrorists, because that would constitute, at least in the form he articulated, an unlawful order under both U.S. and international law, he also didn't seem very, very interested in that, and he shrugged it off and said, "I'm a leader. They'll obey me, whatever I say." And he backed down from that a little bit in the face of a lot of pressure. But I think it's safe to say, at best, that his instincts are not friendly towards international humanitarian law, international criminal law, or international law more generally. His attitude towards multilateral treaties, as you know, has also been quite hostile in a sort of generalized way. So what do we do about this when we have an international justice? To call it an international justice regime would be to overstate it, but where we certainly we've seen some progress, albeit fragile and uneven progress, in international justice, but now we have a new U.S. administration that has come in that is both hostile to the edifice in general, and a president who specifically seems to have no particular moral qualms about suggesting that he would be just fine with ordering massive violations of international criminal law. He's also, of course, spoken admiringly of Philippine President Duterte's death squads. He has spoken admiringly of Vladimir Putin and dismissed others' comments that Putin presides over a state in which numerous human rights advocates, dissenters, journalists, etc., have been imprisoned or assassinated, by saying, when even Bill O'Reilly of Fox News put it to Trump that Putin was a killer, Trump's cheerful reaction was, well, we have plenty of killers too. What do you think? You think we're better than them, etc. So what do we do about this? This is all kind of depressing if you've spent much of your time trying to advance principles of human rights and international justice. And here, there is some faint possibility that Congress, including Republicans in Congress, will be a check on Trump. And I think hearteningly on certain issues, such as Trump's comments on torture and targeting of civilians, we've seen even some prominent members of Congress on the Republican side speak out very, very strongly against that, as well as pretty unanimously the Democratic side. We've seen Senator Lindsey Graham, Senator John McCain essentially say, no way, no how, it's not going to happen, we're not going to let you do it. We've also seen many in Congress on the Republican side, as well as the Democratic side, express an interest and a commitment in pursuing some sort of international tribunal for the Syria, to look at Syrian conflict and war crimes and crimes against humanity in Syria. It's possible. I wouldn't put a whole lot of money on it, but it's certainly possible that Congress will push back against administration efforts to really sabotage international justice institutions, and will also be a sort of restraining influence on the president himself in terms of his own actions and policies. But I wouldn't count on it, and that's why I gave these comments the title I gave them. Those of you who grew up in the United States may remember the campaign, Students Against Drunk Driving and Mothers Against Drunk Driving. In the U.S., the incidence of fatal drunk driving accidents were dramatically reduced after a major publicity campaign by these organizations, and their slogan for a long time, I suppose it still is, was "Friends don't let friends drive drunk." And they really had a big designated driver campaign to say to people, this is not about you risking your life. This is about you taking care of your friends. And if your friend is drunk and is likely to get into an accident, you've got to take away their car keys. You've got to take care of them. And I think we might think in the next few years about the potential role of U.S. allies and partners in particular, sort of friends don't let friends drive Trump, in keeping the U.S. honest and trying to prevent us from doing harm. How can they do that? Well, number one, they can carry on supporting the institutions that are so important, and number two, they can make it clear that there will be cost to the United States of pursuing a policy of hostility to those institutions, and certainly a high cost if the United States commits violations of international criminal law in conflicts it's involved in or elsewhere. In the first piece, just carrying on, obviously, as I said, there's been progress, although it's been episodic. It's going to be really important at a moment when the U.S. presidential administration is clearly at a minimum going to retreat from its support for international justice, for U.S. allies and partners around the world to redouble their support for international justice institutions and for the principles that stand behind them. And that means, obviously, both continuing their political and rhetorical support, but also continuing to provide economic support, intelligence cooperation, and so forth to the ICC and other institutions, to continue to support other promising avenues, such as hybrid institutions and regional institutions. We have seen some interesting, one of the bright spot, the African Union's request that states in Africa withdraw from the ICC, is that the African Union has created some of its own tribunals. And for instance, the African Union Tribunal in Senegal, trying the former president of Chad, was widely viewed as a model of fair and successful regional prosecution for international crimes. And the African Union seems likely to try to create some additional tribunals, and there's absolutely no reason for U.S. allies not to try to support those efforts. There's no particular reason that all international justice has to take place in The Hague, as opposed to closer to home and as opposed to through regional institutions. But finally, I think the international community, and particularly U.S. partners and allies, really need to hold our feet to the fire over the next few years. And that means several things. It means, for one thing, just not pulling punches and being critical when we deserve it. You know, I think ironically, the popularity of President Obama sometimes meant that our allies were a little too nice to us when, under the Obama administration, the U.S. did things that should have been criticized, and particularly over things like U.S. targeted strikes, drone strikes, et cetera, and some other tactics in the war on terrorism, or the war against al-Qaeda and its associated forces, as we now like to call it. There were times when leaders of, for instance, many of our European allies would say privately and in sort of non-attribution settings, obviously we're very, very opposed to what the United States is doing. We think it's a violation of international law. But you put them in a room with President Obama and they would all say nice things, and they would really sort of soft pedal those criticisms, because overall they were committed to, you know, they saw President Obama as an ally, and they didn't want to hurt his feelings. I don't know what they were thinking, but they weren't very tough in their criticisms. So you'd get this funny dissonance between their private statements and statements to their own publics versus the level of pressure that they would put on the United States more directly. I think with Trump in office, we're likely to see less deference from other leaders, and that's actually a good thing, that we are going to need other states to be standing up for the principles that this administration may not be willing to stand up for. And we need other states, our allies and partners in particular, to be willing to exert real pressure, not just rhetorical pressure on the U.S., if we do things that violate international criminal law ourselves. One of the things that, even President Trump, I think, is in the process of finding out, will find out, that no nation can go it alone today. We all need friends. We all need cooperation from other states. And one of the things, I look back on the Bush administration, one of the things that was very influential for the first Bush administration and moving into the second term of George W. Bush, on detainee issues in places like Afghanistan was pressure from allies that was not just rhetorical. When U.S. detention practices and the slowness of notifying the International Red Cross, for instance, when we had detainees in Afghanistan, following a series of decisions by domestic courts and European courts, U.S. allies in Afghanistan, including the United Kingdom and France and Germany, essentially said to the U.S., we can't turn over detainees to you anymore because the way you will handle detainees risks exposing us to domestic or regional prosecution. We would be complicit in your violations of the law, and so we can't turn over detainees to you. Well, the U.S. changed its detainee policies very, very quickly when that happened, because we needed our friends, we needed our allies to be willing to work with us and cooperate with us and turn detainees over to us. And I think that even the Trump administration is likely to find, as it embarks on various international adventures for good or for ill, that you need your allies. You need them to provide you with intelligence support. You need them to provide you with military cooperation. You need them to contribute funding to various ventures and so forth. And when allies say, we won't do that anymore, it starts to hit the U.S. where it hurts. And just as friends should not let friends drive drunk, I think it's friends in the international community should not let the United States get away with doing anything that involves either reneging from our commitments or violating international criminal law. We should abide by it, and it's not a hostile. It is a hostile act for Russia to manipulate the U.S. election. It is not a hostile act for our allies to say to us, yes, we expect you to comply with the letter and the spirit of international criminal law and international humanitarian law. That's what friends do for each other. They keep each other on the straight and narrow. I think the next few years will be a real test for U.S. partners and allies. And in this one respect, I think the general sort of Trump withdrawal from international law and from international agreements, and his hostility to longstanding alliances may turn out to have a longer-term silver lining. I think it will force many U.S. partners and allies who have gotten away with sort of skating quietly by. It will force them to stand up and take their place as spokespeople for and sometimes as enforcers of the international norms that the U.S. is retreating from. And in the long run, I think that's going to be a good thing, to have a larger number of states playing important leadership roles as proponents and enforcers of international norms. Let me stop there, and I'd be happy to take any questions if people have questions or comments.
So my kind of understanding, I haven't been really keeping up with it, but I believe that Trump kind of wanted to withdraw from funding the UN, and at least my understanding of it is that he sees it as a biased sort of institution, given that there are like so many Muslim countries and only one Israel, and with the latest kind of what Obama ended up doing to Israel, there's very bad relations there, and Israel has been one of the strongest allies in the Middle East. So, my question is kind of like, do you see this as almost being, I mean, the UN is definitely a great institution, but do you see it almost as Trump, kind of helping resolve ties with Israel rather than hurting them any more than they already kind of are feeling that they have?
So okay, let me make sure I've got your question right, and also partly in case we have people who can't hear you. So I think if I'm understanding your question right, you're asking whether the advent of the Trump administration and its relations to the UN, will that end up being a boon to U.S. relations with Israel, or to changing Israel's relationship with the UN?
U.S. relationships with Israel. I feel like they are quite tense right now after the Obama administration, especially with the funding for Palestine and the proposal to recognize Palestine as a state, which is very hostile to Israel.
Yeah.
So do you think that Trump's going to kind of mend,
Good question. Like many things, obviously, we really have no idea yet. It's only been a month. On the one hand, obviously, I don't know if I don't think we can equate Israel with Netanyahu and the current government, because obviously, Israel's more complicated than that, just as, thank God, America is more complicated than Donald Trump. On the one hand, clearly the two were hitting it off, and certainly Netanyahu and I think felt much more that Donald Trump was his friend than he had felt with Obama. There was obviously some real coolness between the two. That said, how is that going to play out in terms of U.S. financial support for Israel, in terms of U.S. political support? A little hard to tell, and obviously if I were Netanyahu, I would both be concerned by President Trump's apparent lack of commitment to any particular approach to anything, which may be because he doesn't know very much about it. That would worry me if I were Netanyahu, because I think, how solid is any ally going to be when they sort of seem like, yeah, expand the settlement. Oh, no, don't do that. Oh, okay, whatever. But the other issue that I think the Israeli leadership should be very concerned about is the enormous rise in anti-Semitic incidents in the U.S. and worldwide, which I think it is fair to say that President Trump has not spoken out very vociferously against. And in fact, just the last few days, I've sort of lost count. I haven't followed it super closely, but we've seen several dozen, bomb threats at Jewish schools. We've seen desecrations of Jewish cemeteries. Europe has experienced that trend for a long time. I think this is really the first time we're seeing this in significant ways in the United States for many, many years. And it's really quite shocking. And I certainly think that, when Donald Trump was asked about this the first few times about anti-Semitic incidents, he just brushed it aside and got angry at the reporter and mentioned his electoral success. He subsequently said, oh, yeah, that's horrible, in a sort of passing way, but hasn't made any specific comments on the last few days of incidents. He has, as his top political advisor, a Steve Bannon, a man whose website, Breitbart.com, has very strong links to a number of white nationalist and extremely openly, virulently anti-Semitic platforms. And I think no question about it, around the world and in the United States in particular, and open anti-Semitism has had, open anti-Semites have felt empowered and enabled by the Trump administration. It's kind of baffling to me. It's baffling to me why some of President Trump's advisors, including his son-in-law Jared Kushner, who plays an important role in his White House, have not been more vociferous about saying, hey, father-in-law, you can't just say nothing. You need to be out there. But so if I were Netanyahu, I would be thinking, is this really the ally I want?
Given the trend to kind of revanchist nationalism, I'm wondering what the role for universal or passive personality jurisdiction is vis-a-vis Syria and other places where international regimes of
Yeah. Yeah, it's a really great question. It's a great question, and I don't know, because obviously here again we're seeing two trends that push in kind of opposite directions. Not that surprisingly, we said sort of continued U.S. exceptionalism, which says it's fine for us to assert universal jurisdiction and passive personality jurisdiction over bad things that happen in other places when we feel like it, e.g. Recent congressional action on U.S. court jurisdiction over terrorism. But it is not okay for anybody else to try to do it if it affects us or affects people who we happen to like. That obviously is not a brand new trend. I think that sort of particular brand of U.S. exceptionalism of it's fine when we do it, but not when anybody else does it is not at all new. It's probably been redoubled in this administration, will be stronger. And I think how it plays out, again, partly goes to how other states choose to respond. If other states respond by backing down and by thinking, we don't want to make the Americans mad, the Americans don't like this stuff when we do it, so let's not do it. That will push us in one direction. If other states stand up and say, we don't really care what you're doing in the United States, we think that this principle is an important one, but we also think that it's important that states not exercise it in a unilateral way. It is more appropriate to have universal jurisdiction asserted through institutions that have some regional or international legitimacy, preferably having been blessed by formal regional and international bodies. But it's a great question. It'll be very interesting to see what happens. Any other questions or comments? All right, well, I think, Nora, it is 1:30. Is Nora here? I think Nora has disappeared. Yeah, there she is. It's 1:30, so if there are no other questions and comments, I think we will break now.
Yes, we'll be taking a break. We'll reconvene at 2 p.m. for General Counsel James Baker and Professor Mary Dorson.
Great, thank you very much.
Good afternoon. Welcome. Thank you for coming to the Georgetown Journal of International Law's Conference on International Justice in the U.S. Context. Welcome to our last event. I'm very pleased to introduce our two speakers, General Counsel Jim Baker from the FBI and Professor Mary DeRosa. General Counsel James Baker has worked on numerous national security matters during his career. A former federal prosecutor, he worked on all aspects of national security investigations and prosecutions, including, in particular, the Foreign Intelligence Surveillance Act during his 17-year career at the U.S. Department of Justice. From 2001 to 2007, Mr. Baker served as counsel for intelligence policy at the Justice Department, where he was head of the Office of Intelligence Policy and Review. In that position, he was responsible for developing, coordinating, and implementing national security policy with regard to intelligence and counterintelligence matters for the department. Mr. Baker was an associate general counsel at Bridgewater Associates before accepting his current position in 2014 as general counsel for the FBI. Professor Mary DeRosa is a distinguished visitor from practice at Georgetown Law School, where she focuses on national security law and cybersecurity. She served as deputy counsel to the President for National Security and NSC legal advisor in the Obama administration. She has held other national security positions in the government, including chief counsel for national security for the Senate Judiciary Committee and National Security Council legal advisor during the Clinton administration. She has also been a senior fellow at the Center for Strategic and International Studies and in private practice at Arnold and Porter. Please welcome them as they engage in a conversation on the FBI and international justice. Thank you.
Thank you, and I want to thank Jim Baker very much for coming here. We have worked together and known each other, worked together on and off for many years, and he is a remarkable lawyer and public servant, and we're really very lucky to hear from you today.
You need to lower expectations is the
Yeah.
key to happiness, though. So yeah.
He's okay. He's no. So what we thought we'd do is go into depth on some particular issues that the FBI is engaged in internationally, and I'll ask Jim some questions, and then at the end we're going to leave a little time to open it up for questions. So you can think about your questions, but if the question you're thinking about has something to do with Hillary Clinton's emails or investigations into Russian activities in the election, then probably you ought to think about another question, because for obvious reasons, Jim is not going to be able to talk about those issues, but there's a whole lot he can talk about. So I thought maybe we could start with just a little background. People are very familiar, I think, with what the FBI does domestically and its sort of presence and role domestically, maybe less so with the FBI's overseas responsibilities and sort of footprint. So maybe you can give us just some of that background to start off.
Sure. And Mary, it's great to see you again, and thank you for this opportunity. Shannon and the whole journal, thank you guys for this opportunity. So. Sure. So the FBI, yes, is mainly focused on the United States, the protecting the United States from a range of threats, both domestic and foreign, and also enforcing the criminal law of the United States. And so, in order to do that, we inevitably have to be international in scope as well. And so, I think to think about it correctly, there's sort of like two buckets I would put it in. One is our operational folks that people might be familiar with, counterterrorism in particular, but criminal, counterintelligence, the whole nine yards, really everything that we do is inevitably to some degree international in its scope because of the way that the perpetrators operate, the threats, the threat vectors, and we can talk more about that as we go. Especially also, hopefully we'll talk some about cyber in detail. Yes. Yeah, so we'll talk about that in a few minutes. So that's sort of the operational way we deal with the international world, and I can dive into that in a second if you want. Then we also have sort of a dedicated cadre of folks who focus almost exclusively on international operations. And it's called the International Operations Division, helpfully. And we have about 400 people, I think, and about 300 of them are overseas, and about 100 or so, maybe it's a little bit more than 400, 150 or so are located at headquarters or in the United States. And so the folks overseas are referred to as legal attachés, and they are at embassies. We have, I think it's 63 legal attaché offices that we have around the world, literally around the world, and then another 25 or so sub-offices in different locations. So they have responsibility for covering in one way or another about 200 countries. And so we've got folks all over the world dealing with international interactions. And what they do is, well, as you would expect, they mainly are there to coordinate and to consult with our international partners. Well, with the U.S. government folks at embassies first, and then also with our international partners. And they're trying to assist in joint investigations that we might be running with the foreign partner, with coordinating evidence requests back and forth. We might need evidence from a foreign country. They might need evidence from the United States. So we work on that. A substantial part of what they do is training. So they're over there training folks in what we do, how we do it. Folks are very interested in how the FBI goes about its investigations.
So foreign law enforcement?
So we are training foreign law enforcement on sometimes they're very interested in U.S. law, and so we'll train on that. But then also they're interested in just FBI techniques, investigative techniques, investigative methodology, how we go about conducting oversight, management oversight of our activities, how we deal with technology issues, things like that. So we do a substantial training thing. We in country, if you will, We also then have back at the FBI Academy down in Quantico something we call the National Academy, which is I can't remember how many weeks it is. It's a rather lengthy course where folks from around the United States, state and local law enforcement, as well as from foreign countries, come to Quantico and spend some significant time at the FBI, literally at the FBI, at the Academy, going through a range of courses about how we go about our business, how U.S. law enforcement works, how U.S. legal structures work, and so on. And this is highly sought after by state and local authorities as well as our foreign partners as well. This is like a big deal, and this is really crucial in terms of building relationships with them overseas that then help us do our jobs. I mean, as you can imagine, really in any line of work, having effective business relationships is critically important to being able to be successful over the long term. And so that's what they focus on. So I think so that's it. So we operate in an international environment, both on a very case-specific, pursuing the bad guys overseas, trying to get evidence, coordinating to make sure that something bad doesn't happen overseas, let's say protecting one of our allies from a threat or protecting a U.S. facility overseas from a threat. And then we've also got this longer-term, deep international presence. And I guess sort of just for the law students in the room, I think in terms of dealing with, thinking about the international environment, I think especially in law school, you end up taking courses and focusing on sort of public international law, customary international law, treaties, these kinds of things, and thinking about the legal structure in that way. But then there's a practical, that is in reality, to my experience, a somewhat narrow in terms of the number of person hours spent on that by lawyers and people around the world. That's a small subset of what happens internationally, so to speak, and that all this other stuff is happening at the FBI, at other government agencies. And so for those of who are interested in this kind of thing from a career perspective, you should think more broadly about international law. It's not just, State Department is great and legal advisors at the Office of the State Department is great, but that's not the only game in town in terms of thinking about, I want to work on international matters. There's a lot of opportunities beyond just State Department.
In the government. So
exactly, in the government,
so
right, yeah.
In the U.S. government, you can think more broadly than, say, the Justice Department as well has a big presence outside outside of the country and some others. Well, okay. So with that background, you have, I know over your career, spent a lot of time working on cyber issues, and it is been a major and increasing focus of the FBI over the last really 15 or 20 years, but now a very significant focus. So, and it is by its nature very international. Maybe you can talk more about this, but many of the perpetrators of cybercrime in the U.S. are located overseas. But even if they're located here, the nature of the internet means that investigations would likely be international. So, so maybe I'd like to, just hear. Maybe you can talk about the way the FBI handles cyber investigations. What are the challenges, and in what way this international, quality about cyber, unusually international quality, maybe complicates or challenges the investigations of those issues. And you can start wherever you want, but I think the sort of beginning, number one maybe issue in an investigation is who did it, and that in the cyber area is very complicated. And maybe you can start there and talk about how. That aspect of cyber investigation.
Sure. So I'll just start and then pull me back and guide me in a different direction if I go off on some tangent. So cyber, there's no doubt cyber is international, and any person working in that area, regardless of where you are, FBI, some other part of the government, or in the private sector, if you're not thinking about it in terms of the international aspects of it, you really don't understand it, you don't get it, and you're not going to be able to deal with it. So that's the main thing. so cyber is international, and international is cyber. And I'm kind of flipping those around in the sense that, and cyber, I think sometimes people think about it perhaps too narrowly in the sense of intrusions and intrusion protection and so on. But if you really think more broadly about the role of technology today in society, and how we cannot operate really without engaging with technology in a significant way. And so I think it's important to understand it's important to understand that fact. It's important to understand it both in terms of the threat and then what the threat actors are thinking about and how they're thinking about us and the potential victims. So I think it's important to think about those types of things. I read something recently I thought was quite interesting that I can't remember who said this, so I apologize to the source of it, but basically the most useful human tool today is the smartphone. I mean, like a hammer or a chisel or anything else that we can think of. It is a smartphone because that's what so many people have, and they use it to such a significant degree. Well, that presents all kinds of risks, and a lot of those risks are posed by international folks. So, but in terms of like dealing with this, who done it, that kind of thing. I would say we have to approach that with an open mind with respect to how we go about our investigation, and it is in the cyber environment. It is not a simple question to answer many times. Sometimes it's easy, many times it's not. And one of the particular problems that I'm trying to focus on here is the attribution question, right? That is and has been a key problem that we could spend a lot of time talking about here today in the cyber area. And I guess I would say that attribution is an art. It's an art as much as a science, and it requires analysis and data and facts, and that you have to understand the technology in order to be able to understand the facts correctly. The facts can lead you to an identification, but you have to think deeply about those facts and understand them, and that requires careful analysis. So we really try to do that effectively. I would say that we as a government, federal government, are getting better increasingly about attribution, using the tools available to us. The issue is that the adversaries are also getting better about obscuring the nature and scope of their activities and their location. So it's a bit of I don't know if that's a chicken and egg problem or if that's a cat and mouse problem or just an escalating problem. But it's those two things are happening simultaneously, and so that presents challenging issues.
And so maybe just back up a little and talk a little bit why is attribution why is attribution so much more difficult? And when you say the FBI or the government is getting better, is it getting better technically at tracing back, or are there other aspects to understanding and improving attribution?
So I would say we're increasingly better technologically. We're increasingly better with our analysis of the technology and what it means. And you have to really be knowledgeable about these networks and understand really what is happening and what a particular piece of data means in terms of like how a network has routed material and what the forensic footprint is, if you will, of the data. So that does require specialization, and we have more people who are better at it. Therefore, we're getting better at it. I think that's one way to think about it, right? It's both technology and it's analytical rigor and skill that enables you to better figure out what's happening. And as I say, at the same time, though, the bad guys they know this is a problem. They know this is hard for us, and they want to make it even harder, so they're doing whatever they can, especially focused on obscuring, the metadata, right? The data about data, the metadata, the breadcrumbs, if you will, that are associated with their communications, and trying like heck to obscure that even to a greater degree than exists sort of inherently within the networks. Inherently, there are challenges with respect to attribution because of how communications are routed for lawful reasons by legitimate companies. And then if you layer on top of that some of the techniques that the adversaries use, it's even harder. And then, I don't know if we get a chance, and then you layer on top of that encryption, and then we have a whole nother ball of wax.
Right,
Yeah.
definitely want
We'll
to
come back
get
that.
to encryption. I read something very recently that there are a lot of cyber criminals, cyber actors, who are now pretending to be Russian because of there's so much attention to the Russian hackers that you're seeing a lot of, people have been able to sort of identify when there's Russian that looks like it's, in some of the code, I guess, that looks like it's, gone through a translation app. It just, maybe that's an example when you say they're trying to mask or hide and trying to misdirect. And so it's they're very creative criminals, I guess.
It's extremely creative. It's extremely creative. And so it depends on their purpose and where they are and what they're trying to do and how they're trying to fake us out. And so sometimes they'll pretend to be from particular foreign countries and do things, without getting too much detail, do things to make them look like they're coming from that particular location in a deeper way than just an IP address that happens to show up from a foreign country, to try to really look like they're coming from that location. But then also, we have the problem of foreign actors trying to look like they're coming from the United States for a variety of reasons. One, because we have good infrastructure that is highly capable here, and so they want to sort of piggyback off of that. But secondly, they know they do a lot of research about U.S. laws, and they know what restrictions are going to apply inside the United States. Excuse me. And so they want to take advantage of that, to slow us down.
Yeah.
And even if at the end of the day, if we ultimately figure out where they were at the time they did their intrusion activities, they might be gone by that point. So if they can just slow us down, knowing that eventually we might catch up to where they were, they think they'll be gone from there by a certain point. So it's both things. They want to sometimes look like they're overseas. They want to sometimes look like they're here.
Yeah, interesting. When we talk about cyber and the different, cyber crime or different aspects, what are the, there are different kinds of international actors that are engaging, same sort of techniques maybe, but different purposes. Can you talk a little about who those actors are and maybe what some of the differences are in how, who it is makes a difference in how you have to deal with them?
Sure. So it's nation states that are out there that are highly technically advanced in many instances, very well resourced, both from a technological perspective as well as from a human resource perspective. They have lots of people they can throw at a problem, so they can do that, and I can come back to that in a second. Transnational criminal organizations that operate across the globe that are mostly interested in money. That's what they're focused on. The nation states are interested in a range of different things. In particular, they're interested in information, both about U.S. Government officials, U.S. government classified information, that type of thing that you would think of as more classical sort of espionage, but then stealing personally identifiable information about Americans and stealing it with a long-term perspective in mind. As they monitor who we are and what we do and where we move, and they sort of plot out where they're going to go to take advantage of that information. And then stealing just economic data that's beneficial to them and their companies, right? In addition to then embedding themselves in a persistent way in our networks to continue their sort of espionage activities and then potentially position themselves to actually take what you would think of it more as a cyber attack in the future, should that be necessary. So they're very, very well-resourced and robust in terms of the threat that they pose. transnational criminal organizations after money, also in many instances highly sophisticated, dangerous in terms of, in many ways, but also in terms potentially of the wreckage that they might cause inadvertently. So that's a potential problem. Terrorist organizations are also a threat, both in the the physical world as well as in the cyber world. So that's potentially a problem. Then you have sort of different types of criminals in smaller groups that you might consider organized crime, but not sort of on the scale that I was talking about a second ago. International, individual hackers that are after something, and then you have sort of other types of organizations that maybe aren't interested in damage and destruction or in stealing money, but for whatever reason they want to disrupt the operation of a network or a website or take command of some type of thing.
Okay.
So they potentially pose threats as well. Is that all? Did I answer your question?
You did, yes. And
Okay, good.
but so maybe focus. I don't know what's gotten the most attention, but there's certainly been a lot of attention on state actor hacks and attacks in a maybe not legal sense, but and so maybe you can focus a little. And I'm thinking like the Sony incident and Iran, I guess, with financial sector and some others. In those, particularly Sony and Iran and China with the economic espionage, the United States FBI and the government has gone public with its attribution assessment. Is that, maybe you can just talk about the process there and some of the challenges that presents when you're actually dealing with an investigation of a state actor and how you address that.
So, because of the FBI's role as a national security entity, with both national security authorities as well as law enforcement authorities, we can look at a problem from a 360 degree perspective and try to figure out what is the right or best way to thwart / disrupt the activities of the nefarious actor, as well as bring them to justice. And so we know that it's not always the case that you're going to have something wrapped up in a nice prosecution. You bring somebody to the United States, you put them in a federal court, you try them, convict them, and send them to jail. That happens, but it doesn't always happen. And we've gotten our minds around that, especially, I think, over the last 16 years at least, with respect to terrorism cases. We know that there are going to be other outcomes other than just arresting somebody and putting them in jail here in the United States that will be effective in protecting the United States against the threat. And so I think we try to look at these threats from that 360-degree perspective. Sometimes the best way to thwart them, especially if it's a nation state, you're not going to put a nation state in jail. You can put individual actors, maybe, if you can figure out who those are, but I'll come back to that if I can. So the question is, how do you disrupt these activities, and how do you deter future types of activities like that? And one way is to go public with attribution, because in terms of describing how we think about it. So with respect to that and sort of the process, I mean, I think at a high level, we want to make sure that we're right. So we want to make sure that we've done rigorous analysis of the facts to make sure that we're confident, highly confident, in the attribution that we're going to make publicly. That's number one. Number two is we want to make sure that we have coordinated / deconflicted with other entities in the U.S. government and perhaps with our foreign partners to make sure that they don't have some interest that would be damaged by making this information public. Because you do increase the risk of public disclosures about how you determined that it was country X, and so we have to be prepared to deal with that. You're going to get 1 million FOIA requests for this kind of information, so you want to make sure that you've thought through all the risks and benefits of the attribution. But then that may be the way to go about doing it. I mean, I think the attribution problem is, I think, one of the, and I'm not an international lawyer by training or by trade currently, but I think that is one of the things that inhibits the development of international legal norms with respect to cyber activities. It's this idea that countries have, nation states have, that they can basically get away with it. And so they don't have to conform to the norm because they can kind of sneak around it. And so the norm doesn't get developed and doesn't have the effect that other types of legal norms have internationally that have developed over the years, because you can see that it's a state actor, driving a ship through a particular location or something along those lines. Yeah.
So up until just a few years ago, I think, I'm not aware of the U.S. government having actually identified a state actor as a cyber actor, or and recently there have been quite a few, relatively speaking, quite a few. So is that a movement on the part of the government and the FBI and others to recognize that this is maybe the other way wasn't working and we need to be more public about it?
I guess I would say I think we've gained more experience dealing with the problem and the limitations on the tools that are available to us to thwart the activities. And so, again, it's sort of a risk-benefit analysis to try to deal with these countries and not let them get away with it, basically. Not let them get away with it, to try to hold them accountable, knowing that there's a certain amount of risk involved, but there's also, in making the attribution public, but then also knowing that there are risks involved in not doing it and not doing something to protect our people, our facilities, our information. And so I think we're gaining more experience and willing to try to do different things. If we think we can indict a foreign government official because we have the evidence and we think that would make sense, then we'll do that. If we think attribution is the thing to do, we'll do that. If it turns out that there's some equity out there that that the intelligence community has, for example, that militates against making an attribution public, then we'll hold off and not do that.
Okay.
Right. So I think we're evolving our thinking about the range of options available to us and trying to be very thoughtful, but also aggressive to deal with what is a very aggressive threat coming at us.
Just to maybe wrap up on the cyber issue and lead us into, because I do want to have you talk about the encryption issue related in some ways, but the cyber investigation of cybercrime and cyber activities very much involves the private sector. I mean, the private sector is, for the most part, sometimes it's the government, but largely the victim of a lot of these cyber activities. How do you see this being the FBI interacting with the private sector, and what are some of the challenges there, and how do you work with the private sector to try to make sure that it's an effective relationship?
So we think of companies that have been victimized as victims, and we approach them on that basis, right? The FBI is very used to dealing with victims of a whole range of terrible crimes. And so that's how we think. That's how we think about these a corporate entity, let's say. They've been victimized. They're victims, and we want to try to assist them in that sense. We have a lot of tools that we can bring to bear to try to deal with what may be a persistent, ongoing threat, or to help them understand what happened, and to bring ultimately the people who are responsible for this to justice, if possible, or at least call them out or deter them from further types of activities. Companies are often wary of dealing with us in the cyber realm. There's no doubt about that. And I think a couple different things. One is, I understand that. Having been in the private sector a couple of different times, I get that. You lose a certain amount of control when you start to bring the federal government into it. There's no doubt about that. I think, however, that we've been effective in developing ways to protect their data once, if we have to do some examination of some part of their data or their network in connection with the investigation. I think we've been, A, we care a lot about getting it right. B, I think we've come up with ways to actually be effective in protecting the data from exposure, either, in court, in a proceeding, through FOIA, through whatever, criminal discovery, whatever, to try to make sure that that doesn't happen in an inappropriate way. Obviously, if you end up with a defendant, the defendant's rights have to be protected as well. So trying to figure out that balance is critically important to us. But we care a lot about it, and we care a lot about getting it right. So that's how we kind of approach it. I guess to sort of flip it around a little bit, maybe. So I think companies also are sometimes hesitant. Let me just add this point. They're sometimes hesitant to come to us and expose that they have been victimized, but they don't want that to become public for a lot of different reasons, perhaps because of reputational reasons or competitors that might take advantage of that kind of thing. So that's real, that's out there. What I would add, though, is in terms of folks who are thinking about this in the private sector, there are many great companies out there who offer cybersecurity services to protect them and to do forensic evaluations and so on. But it's important to remember that in many instances, a company is dealing with a nation state on the other side that is trying to victimize them. That, as I said before, is well-resourced, highly technically advanced, and persistent, and can be there for the long term. And the question is really, are you as a corporation able to fend off a nation state? Is that really what you're capable of doing? And even though you might hire some great companies, collectively, are you all really able to do that without assistance in some way from the federal government, from the FBI, from DHS, et cetera? And so I think I would urge people to think carefully about that and really have, not be overconfident, frankly, in their ability to do that, because so that's just it. And I think, just as an aside while I'm thinking about it, look, if you're a corporate leader and you're not focused on cyber, you're missing the boat, because it is critically important in a whole range of ways to your effective operation as a company and perhaps your existence as a company, because not only are people stealing things and have been for a long time stealing intellectual property, we increasingly see this ransomware threat where these malicious actors will find some way to tie up your networks, tie up your data so you can't access it, you can't use it, and you have to pay them a ransom in order to free it up. And so even if you pay it, how confident are you that it's actually going to happen and that they're not still there doing whatever they want to do? So anyway, that's my speech about that.
So it's hard to imagine, given everything that's been out there in the last 5 or so years, that there are corporate leaders that aren't focusing on cyber. Is that something you still see? I mean, has that improved a lot, or do you still think there's a challenge there?
I think there's a challenge there. I think it has improved. I still think there's a challenge there. And I think people are too willing, I mean, I'm talking about executives, are too willing to delegate to cybersecurity folks without themselves spending enough time developing a sufficient level of understanding of what's happening to really, quite frankly, execute their fiduciary responsibilities to the company. I mean, I think that's an issue. I think people need to focus on that.
Okay.
And if I could just, while I'm on this topic, so
please.
also, just for lawyers, my 2 cents to the law students in the audience is sort of similar. I don't care really what part of the law you're interested in. If you are not focused on understanding technology and cyber to a degree of proficiency, you are going to be left behind. You are not going to be an effective lawyer in today's environment, and you are going to increasingly be left behind in your legal career, because it infuses so many different parts of the world today, and that you continually bump into it from a legal perspective. Whether you're in the government or whether you're in the private sector, you need to understand tech to a significant degree.
Well, so I teach a cyber class here, and I always have a similar, but maybe a little bit of difference to the message, because I think you're absolutely right, and I have definitely seen in my time in practice that there is a tendency with cyber issues in particular, or other technology-related issues, for the senior people or others to say, oh, that's tech, I don't get that. That's cyber, I don't get that, and turn it over to someone else, to experts, and therefore, this is lawyers and policymakers, and therefore the law and the policy maybe hasn't developed in as healthy a way as it otherwise could. And what I say to my students is, don't be scared by the technology, and there's a lot that you can understand about how all of this works, and you can work on these issues without being a computer science PhD or whatever. So similar message, but I mean, and I think it's, it is absolutely, I completely agree that if you aren't comfortable with these issues, you've got a lot of the law is going to leave you behind.
That's exactly right. Yeah.
Continuing with technology issues, obviously a lot of attention last year after the San Bernardino attack and the FBI's attempts to get information from the perpetrator's iPhone, and that brought to, I think, public attention the iPhone, which was encrypted, and to public attention this issue of the proliferation of strong encryption and its impact on law enforcement and national security investigations. So maybe just I'd like to first maybe get your explanation of this issue for people who've heard about it but maybe are not completely familiar, and then I'd like you to solve it.
Okay, just here today, we'll just take care of it. So we've talked about the going dark problem, which many people deride it as a name, but anyway, that's what we call it. Going dark, it is essentially the inability of, in our case, the FBI, but really is broader than that, federal, state, local law enforcement, as well as the intelligence community. It's a problem for everybody. It's our inability, with appropriate legal process, to obtain the evidence or information that the law would otherwise entitle us to obtain for some technological reason. That's really what it's all about. We can't get the information because of the application of technology in some ways. Encryption is one subset of that. So I'll talk about encryption.
Okay.
So I've said it before, I'll keep saying it. The FBI supports strong encryption. It is a good thing for society. It protects our data across many different vectors, so personally identifiable information about us, our commercial transactions, our financial transactions, our health data. It protects government information. So strong encryption is a good thing for society. But strong encryption also has costs. It has costs in particular with respect to public safety, because it impacts our investigations. And it impacts our investigations by, in some instances, making evidence or foreign intelligence information simply unavailable. It's just not there. We cannot and will never be able to get it. In addition, it has implications for our ability to conduct effective investigations. So it makes evidence unavailable, but also it slows us down because we have to try to deal with this problem. We have to try to figure out other ways to get at the evidence or to deal with the threat that we have to deal with. Costs more money sometimes, resources simply. It imposes risks. It increases risks with respect to the investigation itself, because we have to do riskier things. So the investigation, if we're trying to keep it quiet and not let the perpetrator know we're investigating, they might figure it out because we've done something more risky. It creates risks to our investigators, an undercover agent that might have to go into a dangerous situation that we otherwise wouldn't have had to do because we could get access to the person's communications, electronic communications. We might have to put human sources in there. So it creates a whole, and we might have to use other techniques that are perhaps more fragile, if you will. So
I'm going to want to come back to that.
Okay.
And have your
So we might have to do techniques like that, and so it creates significant risks for the investigation. It is often argued that we should adopt or use substitutes, and the two that substitutes for trying to obtain the content of communications, which is really what I'm talking about. And so two of those that come off often are legal hacking and metadata analysis. And we do both. We do both. But they are not a panacea. They do not solve all the problems. Legal hacking can be done where you like literally hack into a device.
So this is the FBI is
with a warrant.
With a warrant
hacking into a particular device, as opposed to going to a provider with an order and saying, give me all of Mary DeRosa's email or something. Instead of doing that, if I can't do that, if your communications are encrypted end to end, and that's not available to me anymore, one way to get around that might be to hack your device.
Okay.
And get on your device and try to see what's happening when it's in the clear, when it's not been encrypted. And so that is possible. We can do that. But those types of solutions are expensive. They are fragile because if sort of fragile and short-lived often, because anytime the manufacturer or the software developer changes something, it could throw the whole solution off, and so it just might not work. Those are some of the main, and it's not easy to do at scale if you have a whole network of people, because in order to do that, it's tricky to be able to hack in somewhere. It's tricky. So, metadata analysis is great. We do it to understand communications networks and social networks, if you will.
Can you give me just a sentence or two on what you mean by
So
that?
it's an old-fashioned metadata analysis is understanding telephone records, who's talking to whom, and who else are they talking to, and how does that work, and what do those connections mean? But then you start looking at who people are communicating with through a variety of communications platforms, and just understanding how that network works, what financial transactions the person engages in, what their movements are, if we can understand those. So understanding understanding data about the data. In other words, not the content of the communications, but data about the communications. That's what metadata is, at least how I think about
So
it.
there are a lot of people who would argue, I think, that there's a tremendous amount you can get out of metadata analysis, and maybe even so much that it makes the content analysis or getting the content less important. Is that, what would your response to that be, or your reaction to
Metadata
that?
is highly useful, and we use it. There's no doubt about that. But it is not everything. And so it can tell us who's talking to whom, but it doesn't tell us about what. Right? So we might have some leads from some other source that says these are two bad guys, and so we see, yeah, they talk a lot to each other. But we don't know what they're talking about. And this came up in the threat where in Garland, Texas, that ended up with the perpetrator being shot by local law enforcement. And we could see in that instance, for example, that the perpetrator was in contact with a terrorist operative overseas, I can't remember the number, over 100 times. But because of the platform that they were using, we couldn't see what they were talking about. We knew they were talking, we didn't know what they were talking about. And so, but for those law enforcement folks at the scene, something extremely tragic might have taken place. So that's kind of what I'm talking about. Metadata is good, it's useful, it's not everything. It doesn't tell you about the capabilities, plans, intentions, or activities of the threat actor in the same way.
So
Look, we are not, the FBI, are not trying to impose some solution on society. We don't have I'm sorry, I'm not going to solve it today. We don't have the solution for this problem. We don't. We understand that. We're not trying to force American companies to adopt some type of, or the American people to adopt a back door or give us some golden key that undermines cybersecurity in some significant way. We don't want that.
okay, so that's not, there's no pushing a particular legislative solution to build a backdoor or anything. And
No.
why, I assume it's because you don't think that would be useful. Why is that?
Well, so the concern that we would have about that particular, a thing that would actually be a backdoor that would be threatening would undermine even further our cybersecurity. Let's just remember, cybersecurity is not some perfect state that we're in today, and that the FBI is trying to get people to weaken that thing which is perfect. It's not perfect now, so there's risks associated with it now. But we don't want to make it any worse, that's for sure. So we don't want to do that. We want to protect people's privacy. We want to protect their personal information. We want to protect their rights of association and free speech, so we need to do that. We want American companies to be competitive and innovative, especially in the global marketplace in which they must operate. So we want all those things simultaneously. That is hard to do, and I don't think anybody's figured that out. There are some interesting ideas that have been put forth. Matthew Tate on lawfare had put out a multiple envelope concept. We can talk about it more if you want. But anyway, so there's certain things that are worth exploring probably in terms of getting an appropriate balance of all these things. But I think, as President Obama said, you can't be absolutist about these things. And we need to find something that is an appropriate balance for American society. And so at the end of the day, look, what we're saying is we, the FBI, work for the American people. You have given us a responsibility to protect you from a range of threats and to enforce the criminal law. And so the question is, what tools do you want us to have? What information do you want us to have available to us in order to do the job that you've given us? And so that's the question. We're trying to tell people this is a problem. We don't have a solution, but the country has to make some choices. If it does nothing, that's a choice, because technology will continue to evolve, and it changes every day, and encryption is spreading more and more, and in some ways that's good, but it presents more and more challenges for us.
Okay. I guess we have about 10 minutes left. Maybe we should go see if we have any questions on this or any other issues. I don't know if there's, okay, yes, question here.
Do you think that in the present legal tech market, the products for cybersecurity satisfy the needs for the law firms or for the corporations?
So is the legal, I'm trying to understand, is the legal regime that we have in the United States up to the task right now? Is it sufficient to deal with the threats? Is that your question?
Yeah, I think the products developed for maintaining cybersecurity, are they
The products?
satisfying the need of the law firms to be secured in the cyber world or for the corporations?
So are the products that we have now sufficient to satisfy the needs?
Well, there continue to be breaches on a regular basis. So I think the answer is no. And so the answer is no. So the threat actors are constantly looking for vectors into our systems across the board. And so, so I think any person, any corporate entity or any person needs to be aware of that, needs to be mindful of that as they're thinking about how they set up, maintain, operate their networks with respect to how they, what data they put there, how they handle it, and then how they hold their corporate security people accountable for dealing with the problem as I described before. It's a extreme, I'm the lawyer, not the tech guy, but at the end of the day, it seems that these systems are so complex that it's hard to manage them effectively from a cybersecurity perspective. So it's a big challenge.
And maybe as you said earlier, the answer would always be no, because as soon as you have products that are sufficient for the current threat, the bad guys figure out a better way or a different way to do it, and so it's just always.
That's exactly right. It's an escalating thing. Yeah. And the complexity of these systems is growing. It's not getting. They're not getting simpler, I don't think. Yeah.
Yes, back here.
I imagine you have frequent conversations with the State Department, especially as you're kind of discussing how to disrupt the nation states, the threat actors. So what do you see their role as? What do you think they see their role as? And how do you kind of resolve the probably inevitable clash of interest there?
Well, at the end of the day, the National Security Council is going to resolve the any disputes that we have with your former employer. So Mary was involved in a lot of these interagency disagreements, disputes, arguments, and so on. I mean, that happens all the time. It's not just cyber. Agencies have different perspectives and argue with each other. And I would submit to you, even though it's painful sometimes to be in that process, it's for the country, it's actually a good thing that agencies are arguing and disagreeing with each other, because no one agency is so dominant that that its interests override those of others, and so I think that actually is a good thing. And so, yeah, state is thinking about the diplomatic implications of what it is that we're doing and what that means for our relationships with foreign countries today and over the long term, and how we're going to think about that. And so it's a totally legitimate thing to worry about. We obviously have highly effective relationships with the State Department, even if we argue with them and the other agencies from time to time. So, but that sort of interagency tension and collision sometimes, I think ultimately is beneficial toward producing a better decision. And sometimes it has to be resolved, and ultimately at the end of the day, the President of the United States has to make decisions sometimes about these kinds of issues. You try to resolve it before that and come up with some creative solution. But it can be challenging.
And I guess this is, I would think it's always challenging if you have an international focused investigation. Probably have to work with other agencies and State Department in particular more than you would in your sort of run-of-the-mill and the FBI's run-of-the-mill investigation.
Well, that's true. I mean, that's true. The international aspect of it complicates it to a significant degree. Or investigations in the United States are complicated too very often, because especially if it's a cyber investigation, even if it's just domestic, it's going to be complicated. But there are 18,000 law enforcement entities in the United States, and so our ability to maintain good and effective working relationships with them is crucial to our success as well. And so that there's complexity all around us when you start to talk about anything other than the simplest kind of offense investigation. Yeah. So.
I think I saw one over here. Yeah.
On the topic of corporate security, is there ever a point at which your advice is not use computers, so if there's enough email needs to just say this type of communication is best done in person or on a landline and not to use a computer?
So, A, what do I really know? But B, yeah, I'm guessing that over time, I think especially emails days are numbered. That's just my guess because of the risks associated with that. And I don't know what that means and where communications will go. I know that I'm familiar that there are, I'm not going to say how secure they are because I don't know, but I know there are already companies that are marketing and delivering alternatives to email, especially sort of chat/text-based ones. And anything that's written down is potentially vulnerable. And so I think we all need to think about that in terms of what data we have, what data we keep, and how we just mitigate those risks. The risks are there. You're not going to get away from them. The question is how do you mitigate them, and how do you strong encryption of data at rest is a good thing for that's really well managed, right? Because encryption, even if you implement it, it's often hard to manage it effectively. That's tricky, and you have to make sure that you're devoting effective resources to that as well. So it's a challenge. It's not going to go away. And anyway, that's my response to your question.
I'm a little trouble seeing out here. Any other? Oh, okay.
Hi.
Hey.
Thank you for speaking with us today, both of you. Assuming that cybersecurity will continue to be a concern for an extended period of time, is there something else on your list or the FBI's list with regards to international relations or the behavior of other countries that you're keeping your eye on?
Yes, you betcha. So, yeah, we're trying to protect the American people from all these foreign threats, and cyber is a particularly worrisome vector because we've decided as a society to depend upon it so much and depend on technology so much and to put so much of our valuable data into such systems and therefore put them at risk. But if foreign countries and other foreign threat actors are interested in undermining us in a variety of different ways, and so we need to be thoughtful and vigilant about that. I was reading recently about some of the, in terms of human thinking, there's sort of rationality and there's perception and then there's action associated with that, and that in reality, understanding perception and understanding how to take action is in some ways more challenging to completely figure out than rationality. Sort of once you get something once you figure out what something is, you can put it into a bucket and you can deal with it. But perceiving what's happening, especially when the other side is trying to obscure your ability to see it intentionally and very, very well, that can be challenging. So making sure that we are adept enough at understanding what these threats are, whether they're coming at us from cyber or through some other means, that's very tricky. That's very challenging. And to make sure that we, obviously, we need to do so in a way that's consistent with and adheres to the Constitution and laws of the United States and the values of the American people. And so that's hard. That's hard.
Okay. Yes.
Do you think that for the public sectors like FBI, you are trying very hard to decipher things, but for private sectors like the big companies like Apple, they're trying to deal with encryption. So I don't know how they, like public sectors, compete with the private sectors to draw more talented people to do your work in these separate areas.
Yeah, so I'm not sure exactly the thrust of your question.
Tell me if I've understood correctly, the difficulty of bringing technology, people with a technology expertise to the government.
Into the government, yeah.
FBI or other places, and is that
It's a competitive marketplace, and we're trying to do the best to attract people to us. I think the thing that, we can offer a certain amount of money, but in many instances not as much as the private sector offers. But we can certainly offer something that I think a lot of people will be attracted to, which is our mission. Yeah. Our mission to protect the American people and to do so in a way that upholds the Constitution of the United States. And so that is compelling to people, especially, look, for senior tech people who may have spent some time and have made an amount of money that they deem sufficient to come and spend some time with us is something we want to do. And recruiting people, early, in college, or getting high school students interested in science and computer science and that kind of thing is critically important. Making sure that we have an innovative environment internally to try to deal with this, again, obviously consistent with the Constitution and laws.
Yes, so it can be a real culture clash sometimes if you've got people coming out of the private sector, the tech sector, and then the government culture is a little different.
Yes, it can be, but as I say, your average FBI agent or analyst today have to be sufficiently, just like I was talking about with lawyers, you have to be up to speed on technology and cyber. And so our folks are more exposed to it than ever before. And so I think those kinds of cultural divides are getting less. I think, I'm not saying it's gone away, but I think it's not the way it used to be. And we certainly see the importance of being able to have folks who have different perspectives, have different backgrounds. Yeah,
terrific. Okay, well, so I think we're out of time here. Thanks so much, Jim, for spending time with us and for a really interesting discussion.
Great, thank you.